Hello, and welcome to the DC Bar Pro Bono Center's webinar, Intellectual Property 101 for Startups. I'm Christine Kulumani, staff attorney with the Pro Bono Center's nonprofit and small business legal assistance programs. First, thank you to my colleague, Lauren Paley, who has done all of the behind the scenes work to make this webinar possible. And a tremendous thank you to our presenter, Shahed Kader. Shahed is managing attorney at the Law Office of K.S. Before we get started, I'd like to go over a couple of logistics for today's webinar. First, for those of you listening to us live, this webinar will be recorded. To access the recording, please complete the post-webinar survey that we will email to you. In addition, you have immediate access to the presentation slides in the GoToWebinar control panel under Handouts. If you have questions as we go, please send them to us through the questions box in the GoToWebinar control panel. We've set aside quite a bit of time at the end to address the questions that you send in today, as well as the questions that you included with your registration. And with the mechanics of today's webinar out of the way, let's get to the main topic. When starting or running a business, you often hear, and maybe even sometimes think, about protecting your intellectual property. But what is intellectual property? What can be protected? And how does it apply to you? And with that, I'll turn it over to you, Shahed.
Awesome. Thank you, Christine. Thank you so much for the kind introduction. Hello, everybody. Thank you for joining today's webinar. As Christine mentioned, this is Intellectual Property 101 for Startups. My name, once again, is Shahed Kader. I'm managing attorney at Law Office of K.S. My practice focuses on transactional law for software companies, and I'm licensed to practice law in Washington, D.C. and Maryland. Quick note before we get started, nothing in this webinar, slideshow, and presentation is to be taken as legal advice. If you are seeking legal advice, please contact your attorney or work with the DC Bar Pro Bono Center. They should be able to assist you with that. That being said, I'm happy to get started. Today's presentation, Intellectual Property 101 for Startups, we will be covering what is intellectual property and the different things like what is copyright, trademark, trade secret, and patent. So first and foremost, it's basically intellectual property, or IP, is basically your work product. IP can cover everything around your company, including but not limited to your software code, your name, your logo, the formula and application or algorithm you use, right down to your marketing content, even these blog posts. And technically, I can consider this presentation copyright of my law practice. I'm sure you've heard the terms copyright, trademark, trade secret, patent. These get thrown around a lot, and I'm sure you've Googled them all as well. The thing is, they're all different things, and they can't be really interchanged, because different things can be patented, different things can be trademarked, different things can be copyrighted, but not the other way around. So what we're going to go over in this presentation, in this webinar, is just giving you a breakdown of what these different terms mean and how they apply to different types of startup businesses, specifically software businesses, if that's what you're doing, but startup businesses in general. How do you differentiate between each, and what's the governing body of law? So that's what we'll cover. Let's get started. The first one, of course, is copyrights. Copyrights, the governing law, is Title 17 of the United States Code and Copyright Act of 1976. You're going to get course material as a part of this webinar that's as an attachment, and these links are live in that course material. So please feel free to check out these links. The question, of course, is what can be copyrighted? And this is definitely, this answer is taken directly from copyright.gov, the actual website for the Copyright Office of the United States, and their basic circular. Literary works, so that means books, content like that, anything written, magazines could be copyrighted. Musical works, including words, so lyrics can be copyrighted. Dramatic works, including the music in dramatic words, so if you're writing a Broadway show, the music is copyrightable, as well as the words of the music, drama itself. Pantomimes and choreographic works, so actually dances can be copyrighted. Pictorial, graphic, and sculptural works, motion pictures and other audio-visual works, sound recordings, which are works that result from the fixation of a series of, this is the technical definition, so works that result from the fixation of a series of musical, spoken, or other sounds. So basically, if you're recording a sound or recording a song, it could be copyrighted. Architectural works, and for software businesses specifically, your software code can actually be copyrighted. So what can a startup copyright? For example, software code, as I just mentioned, and content, marketing and otherwise, in written, photographic, or video form can all be copyrighted. So if you're making marketing content that's a blog post, that's a one-pager, or anything of the sort, or even photos that you take on behalf of your business, that could all be copyrighted. Do you have to register your your copyrighted material? Technically, no. As soon as you create something, you own the copyright. Registration, however, is voluntary. However, if you wish to bring a lawsuit for the infringement of a United States copyright work, then you should register with the copyright.gov office. So basically what I'm saying is, as soon as you write something, you can say copyright 2021, my name, Shahed Kader, and this is a copyrighted work. And yes, it is protected technically by copyright, but you can't really go to court with that. Best case scenario for that, or best option for you, is to go to copyright.gov and go through the simple process of registering your copyrighted material. You can also work with attorneys to help you with this, but the website copyright.gov really has some great directions for you to do so. It's easy and relatively inexpensive, and the excellent instructions are there. Next, let's talk about trademarks and service marks. So governing law is the Lanham Act of 1946. Question: what can be trademarked? Phrases, words, symbols, devices, colors, logos, and slogans are all things that can be trademarked. For example, Coca-Cola can be trademarked, and the Coca-Cola logo can be trademarked. So that's a word mark as well as the logo. Both of those are separate trademarks. Just do it from Nike. It's a phrase, that's a slogan, that's trademarked by Nike, and Nike itself is also trademarked. And then the Nike logo is also trademarked. So that's 3 separate trademarks that are there. The difference between trademarks and service marks, they're essentially the same thing, but service marks represent a service being provided, and trademarks are more of a product being provided. So for example's sake, if you're an accounting firm and you want to register your trademark for your accounting firm business, that you would probably be a service mark. But if you are Ford and you want to register the trademark for Mustang, that's a trademark, and that's the word that you're going to be registering. What can a startup trademark? Your name, your logo, and slogan and product names can all be trademarked. For example's sake, I'll use Ford again. Ford is registered as the name Ford. They also register the logo, the blue oval Ford. They also register each car name. So Explorer, Mustang, F-150, all of those are registered trademarks. Those are separate things, logo, slogan, product names, that are trademarked on a regular basis by these organizations. Keep in mind, there are already millions of registered trademarks with the United States Patent and Trademark Office, and even more internationally. So if you are registering your trademark or looking to register your trademark, it's very important to do proper research on what is already registered and what you can use before you get slapped with an infringement claim. Registering a trademark requires research into existing marks out there and filling an application with the United States Patent and Trademark Office. Just a little bit more information on trademarks. There are 45 different classes when it comes to trademarks. So just because one thing is registered as a trademark doesn't mean you can't register yours, as long as it's in a different class. For example's sake, I'll use Mustang again. Mustang is registered as a car with Ford, but it's also registered, I believe, as a lawn care product in a completely different class. So out of those 45 classes, 35 of them are goods, and then 10 of them are services. And the difference is, once again, if you're trying to register something and the name already exists out there, that's okay. We just need to make sure that it's not in the same class as what you're doing, and then you have a better chance of registering that trademark. There's a lot more caveat to actually registering trademarks. I wrote a blog post about it. You're welcome to visit my website and check the blog out. But the most important thing is to ensure that whatever you're registering for a trademark, or whatever you want to register for a trademark, do your research, make sure it's not already out there, make sure that you are registering it in the proper class, and then follow through with the entire application process. Next is trade secrets. The governing law is the Uniform Trade Secrets Act, and there's also an updated act from 2016. So what is a trade secret? Forms, formulas, practices, processes, designs, instruments, patterns, commercial methods, compilation of information not generally known or reasonably ascertainable by others, by which a business can obtain an economic advantage over competitors or customers. Now, in a nutshell, trade secret is something like KFC's formula. They actually consider that a trade secret. It's also Coca-Cola's formula. They consider that a trade secret as well. Software code is generally considered to be a trade secret as well. So for example's sake, what can a software company consider to be a trade secret? Anything that sets you apart, really. Your application code, your algorithms, your pricing structure even, business model, or even the unique setup of your compensation plan can be considered a trade secret. They are a part of what you transfer over as intellectual property when you form a company. From your founders, your employees, to the company itself. The company should own the trade secrets when it comes to trade secrets. How you register a trade secret? There's no registration of trade secrets. That's why it's a secret, right? The whole point of trade secrets is that you don't have to divulge it anywhere. You don't have to register it anywhere. However, they are protected by legal agreements, such as employment agreements, non-disclosure agreements, work for hire agreements, non-compete clauses between the company that owns the trademark, trade secrets, and the employee, contractor, or business partner. You as a startup also have to take measures to protect your trade secrets, keep them safe and not just laying around in an office or an open Dropbox folder. If there is ever litigation around your trade secret, if you're claiming that someone took your trade secrets, you need to be able to prove that you had appropriate safety measures in your trade secrets. So that's how you protect a trade secret, and that's what's considered a trade secret. There are also laws around it. If a trade secret of your company is acquired by another company by illegal means or espionage, if you want to sound cool, then the secret is deemed to be misappropriated. So that's at which point you can go into litigation. You could go after somebody that's allegedly taking your trade secrets and go through that entire process. Finally, patents. So the governing law for patents is the US Patent Act. What can be patented? Inventions can be patented if it has a useful purpose, has a patentable subject matter, is novel, and is non-obvious. It's a lot of technical language over there. That just means it needs to be new and not obvious. Patentable subject matter, also known as patent eligibility, is defined by the US Patent Act as follows. Whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new useful improvement thereof, may obtain a patent, therefore, subject to the conditions and requirements of this title. Pardon the typo there. Basically, what this means is you can patent something if it's something new, if it's improving upon something and it doesn't already exist out there. Some examples of patentable subject matters includes pharmaceuticals, electronics and machines, computer hardware, business methods and processes, fabrics and design, computer software, sports equipment. These are all patentable stuff. Even the way that an engine works can be a patentable subject matter. It just depends. What you would do, patent is a very specific body of law, and it's always recommended to speak to a patent attorney specifically about what can you patent and what you can't, because they'll be able to direct you in the direction to understand whether what you want to patent is actually patentable. So what can a startup patent? Basically anything mentioned above applies to startups. Should you choose to patent, know that there is a time and cost-intensive process around patent research and registration. So you have to do the research, just like it's trademarks, to make sure it's not already out there. Then you should do the research to make sure that it is patentable. And then keep in mind, this is a very major part of the difference. Keep in mind that patents are publicly available, whereas trade secrets are entirely private. So the reason I bring this particular portion all up is because when specifically dealing with software companies, some don't necessarily want to register their software, their algorithms as a patent, because when you register a patent, it's publicly available to anybody. Anybody can search the patent database and find everything that you patented and use it for their own use. However, of course, there's going to be licensing issues and whatnot that comes into play. And it's just a lot of software companies prefer not to go out there in the first place. They do recommend, however, going for registering a copyright, because with copyrights, you don't necessarily need to give your entire software code. You can just give partials of it, just to show what's different out there and what you're trying to copyright. So there is a difference there. But software companies that I work with generally prefer to keep them trade secrets. That way, it's not out there in the open, it's not searchable, and they get to keep their information or their secret sauce kind of secret. So that's essentially the differences between copyrights, trademarks, trade secrets, and patents. There are 4 different bodies of laws that cover what is each. Copyrights, more so, you're looking at content, you're looking at photos, you're looking at movies and music and all of those things. That's what you can copyright. Trademarks is more like names, slogans, logos, trademarks, things that identify you. Trade secrets is something that, it could be anything. Anything can be considered a trade secret. It's just that it's very important, if you are considering something a trade secret, if you want to say, hey, this is something that I want to remain a trade secret, you should and absolutely must take appropriate measures to protect that content as trade secret. Because if there is ever litigation, if there's ever a reason to sue somebody, and it's discovered that, hey, you're not actually protecting this, it's just open in a Dropbox folder, or no one's actually being penalized for sharing this information, it's not even marked as confidential, then you lose that trade secret rights, and then there's nothing there. And then finally, patents. Anything mentioned above can be registered as a patent. Something that's new, software code, pharmaceuticals, all of those things can be registered as a patent. But once again, that's a much more technical piece of law, that it's important that you speak to you get the appropriate advice when it comes to patents, because that actually requires a lot of in-depth research as to what's out there and what's available to you. So I believe, Christine, we can, that's the end of the presentation. If you want to pass over to questions, I'm happy to do so. Just a quick note, whatever questions you may ask, I cannot give you legal advice. We have no attorney-client privilege. Don't share any confidential information. But I can give you high-level answers to any question that you might have.
Fantastic. And so I'm going off of the questions that our listeners sent in ahead and have already sent in. If you're listening live and you have more questions, please do continue to send them, and I will get to that. Let's see. To start out, when you want to copyright something for your business, you talked about that it should be, for words, they should be written. Would that include, what's writing? Is that a blog post, putting something on social media, or does it mean actually physically writing and typing and having a hard copy?
Yeah, it's a good question. So social media is a tricky thing, right? So social media, any social media platform that you post anything to, they have their own terms of use. They have their own terms to who owns the copyright to what you do. So I can't really answer whether you can copyright something that you post on social media. It just depends on which social media platform, whether it's a Twitter, Instagram, whatever else. Usually they allow you to keep your copyright or the rights to whatever you post. However, on the other side of things, you give them an irrevocable license, like perpetual license to use that however they see fit. So that's another way to look at it. That being said, the answer to your question is anything. It can be a blog post. Like my blog post, anything that I write on my blog, I have a copyright notice at the bottom that this is a copyright of Law Office of K.S. Kader PLLC. Do not infringe on my copyright. So it could be anything. But if you're posting on a separate platform, like a social media platform, it could be. It really depends on what their terms say.
Is it important when you have a copyrighted work to put, on the handout or the website or the blog post that it's copyrighted, or is that not important at all?
I mean, I think it never hurts to put the copyright notice. Like, on the bottom of my website, I have very clearly written copyright 2021 Law Office of K.S. Kader. If you want to protect something, if you want to just let it be known that this is something you created and you're retaining the rights to it, I think it never hurts to actually put that copyright notice. Does that answer the question? I'm not sure if that was the point of the question.
I think so. Seems that does. So, say on the internet, there's something out there, doesn't say that it's copyrighted, it's available for free, maybe a song on YouTube, or a picture from, Google image search. Can a small business either use that in their materials on their website or link to it, maybe in a blog post?
That's a good question. The answer is generally no. Anything that's always out there, unless it very specifically says that this is free to use, there you have the license to do so. You likely don't have the license to do so. Google Images is kind of notorious for this stuff. It pulls images from all over the internet, and whether you have the rights to them or not, people still use it all the time. I have seen instances where people get cease and desist letters saying that, hey, I own the rights to this image, and you shouldn't be using it. YouTube is usually quick to take down copyrighted material. They are very quick to their DMCA, Digital Millennium Copyright Act responses. So if they hear copyrighted material, or if their machine learning finds copyrighted material in their work, they usually take it down pretty quickly. That being said, it is not a good idea to, if it's going to be used in a way that makes you money, which is marketing for your website or putting it on your website or whatever it is, it's usually not a good idea. That being said, there's also a part of the copyright law that's called fair use. And fair use is really related to specific uses, like for the news. If it's not going to make you money, if you're simply reporting the news and you're not trying to monetize off of that, off of the logo that you might be reporting for the news, that's sometimes allowed. What I would recommend is really looking into what fair use means and what it applies to, and applying it to your use case. For example's sake, if you are planning to find Google Images, find a bunch of stuff on Google Images and put it together as a presentation and then sell that presentation, or put it on your website and use that as your stock images for your website, probably not a good idea. You're probably infringing on somebody's rights. It's just the same as if you were to take a photo of your home and you put it up on Instagram and someone just screen captures that and uses it, put yourself in their shoes, uses it for their own purposes. That's your copyright being infringed on.
Great. Some more on copyright. If, maybe a software business is looking to copyright and protect a code, could it cause problems, or would it matter if they've published the code, maybe online, GitHub, or a similar site before they register a copyright, if they, in the future want to have the ability to bring an infringement claim?
Yeah, it's a good question. So, specifically when it comes to GitHub, GitHub actually, you get to choose which license that you're putting under whatever code you're uploading. So if it's an open source code, GitHub is usually for open source code. It's not recommended that you put any private or personal code or code that you want to protect on GitHub unless it's a closed repository. If it's an open repository that anybody can search, you get to choose like which open SSL license that you're using for that software code that you're putting up there. So good idea versus bad idea, it really depends on your use case. What are you doing? How are you protecting it? What is your intention with it? Is this open source code that you're giving, that you're trying to put out there? Then fine, just put it on GitHub, and then you don't have to copyright anything because the open source license is what governs it. However, if you are trying to protect it, put it in a protected GitHub repository that you can share only within your company and only with people that have contractual relationships to keep trade secrets private with you.
Great. Moving on a little bit to trademarks. Can an organization trademark something other than their legal name? So for example, a trade name, or maybe the name for certain programming or lines of business?
Yeah, absolutely. I mentioned to you earlier during the presentation that Ford not only registers their name Ford, but they also register Mustang, which is a product. Trademarks work in a way where you can even register something before if it's in market, but you have to file with an intent to use application. It's a separate marking on the application that says I intend to use this in the next year or something like that. So it is not unheard of for major corporations or companies in general to preemptively register a trademark for a name that they plan to use in the future. But that being said, you still have to 100% make sure that you do appropriate research to make sure that names are not already out there, because either A, you're going to get rejected by the United States Patent and Trademark Office for one of the multitude of reasons that they reject applications, or B, if for whatever reason it goes through the USPTO, you will run into issues with whoever owns the actual trademark. But to answer your question, yes, you can register name of products, you can register slogans, all of the above.
Great. You mentioned that big companies register an intent to use before they actually start, using the name of whatever line or product. From a practical perspective, based on your experience, is there a certain point in the process of starting a small business that it makes sense for a new business newer business to, trademark their name and logo if they have the money available?
I mean, that's a good question, but it's also a very personal decision, right? So it is very dependent on what you're trying to do. So I'll give you an example. If you're a software company and you plan to launch a piece of software and your goal, your intention is down the line, you want to raise funds from venture capitalists, right? That's kind of the way that software companies go. If they don't bootstrap, they raise funds from venture capitalists. Well, venture capitalists, what they'll do as a part of deciding whether they even want to invest with you is they're going to do due diligence on your company. And part of that due diligence is to ensure that you own the names that you're using. You own the trademarks. Not all of them do this, but this is more common than not. Because ultimately, what they don't want to do is you don't want to spend so much time working and building a brand and saying that, hey, this is my brand, John Smith Incorporated. This is my brand, and all of that, and making all the marketing material and investing in that. And all of a sudden, you'll get a cease and desist letter that says that, hey, actually, we own the rights. We've owned the rights since 1987, and you need to change your name right now. And you don't want to get into that battle. And on top of that, and that's what the venture capitalists are looking at, right? They want to make sure that they're not going to run into any trouble with this company that they're investing in because they don't own the rights to their trademarks. So that's just a specific instance for software companies that I see. As far as small businesses, really, it's entirely up to you, right? Like I know plenty of small businesses that have registered trademarks for their restaurants and for even products that I've seen. And it's really there's no right answer to that. The only thing is to look at your circumstance and see what your ultimate goal is, and to know that if you do want to raise funding, there are going to be certain entities that want you to make sure that you own the rights to your trademarks. So that's just the way to look at it.
Okay. In terms of trademarks, if there are two businesses with the same name that they're using, are there any rules that governs who gets to continue using it if they find out and they're butting heads and it's confusing customers?
Yeah, absolutely. I mean, that likelihood of confusion is a major reason that United States Patent and Trademark Office reject trademark applications, and they won't even let you get to registration if there is another company. That being said, this is also why there are 45 different classes in trademarks, right? Different classes means there's different categories of products. So if your company's name is X and you're registered as a software company, then X, the other company that's registered as a lawn fertilizer company, they really don't have a standing because you're on two different kind of planes as to what you're doing. It's not likely that you're actually going to be confused. The rule is do the research ahead of time before you choose a name and before you decide to go to market with it, and do your best to try to figure out if there's something else in a similar market that's going to cause confusion or a likelihood of confusion, which once again, it's one of the main reasons that USPTO rejects trademark applications, and to ensure that you're not going to run into that issue. What will end up happening, or what could end up happening, is that it could be that you get to registration and now you get a cease and desist letter. That's when you have to go to court, right? And at that point, you guys are going to have to figure out an engagement or an arrangement legally who gets to keep the name, who has to drop the name, and all of that.
Awesome. So once a small business, decides they're going to file for a trademark, it goes through the whole process and it's granted, are they able to then add additional classes for that trademark?
Yeah. You can. It'll essentially be a separate application altogether, and it'll go through the same process, right? It'll go through another 6-month process of going to a trademark attorney's office, and they get to review the application. You'll have to do research as to whether that name already exists in a different class and go through that. But anytime you add a class, it'll essentially be a whole new application.
Okay. And when you're filing a trademark application, does it cover just one word or symbol or phrase or logo? Or does a business apply for a trademark for multiple together? For example, their name and their logo and their slogan.
Yeah, absolutely. It's multiple, right? Every single one of those are separate trademarks. Your name is one trademark, your logo is a different trademark. Even if your logo is word type of your name, right? Like even if your logo is Nike, stylized as Nike, that's a separate trademark altogether. Your slogan's a separate trademark. I've filed 7 different applications for one of my clients, and that covers the name, the logo, the slogan that they want to use, the slogan of a product, different product names, all of that. So those are all separate trademarks.
Okay. Do trademarks expire after they're issued?
Yeah, it's a good question. So trademarks, the way it works is after you're issued, after 5 years, you're going to get a notice and they're going to ask you, hey, do you still have this trademark? And you have to answer, you have to actively answer, yes, I still have this trademark. And they said, okay, cool. Then you have another 5 years before they call you again, right? And say, hey, do you still have this trademark? And you have to respond that, yes, this trademark is still active. Okay, cool. And then after that, you have 10 years. So it's time after time after time, you'll get pinged every 5 years to 10 years, whether you still have the trademark. So they do expire. You do actually have to actively go in and apply, put in the application to say that, hey, I'm still using this trademark.
Okay. And when you say, yep, still using it, do you have to pay again or do you just pay up front? That's a very common question we're getting.
Yeah, you pay again. There's a separate fee for saying, it's not the same fee, it's not the same amount. I believe it's $100 now to say that, yeah, we're still using it. A statement of use is what it's called.
Okay, great. When a small business is looking into names and other trademarks, you talked about doing some research online, looking things up, maybe getting legal assistance for that. But are there other steps that they should take outside of doing this research with the Patent and Trademark Office on names, logos, slogans, to make sure that this business might be free to use it?
Yeah, I recommend talking to an attorney and getting an opinion letter, right? So for example's sake, what I do for my clients is I do a comprehensive search, which includes the federal USPTO register, state registers, because all states have separate trademark registers as well. So if you're a local business, you can consider just a state register instead. We're just talking about federal trademarks here. The common law, meaning is the name even out there? Web search, web domains, are there web domains registered with that name? Social media search. These 5 or 6 different things I will run a report on. And what I would do is I would analyze the report, tell you which might cause problems, and then give you an opinion as to whether this is a good idea, this is a bad idea, this is the issues that you might run into, et cetera, et cetera. So what I would recommend is doing a comprehensive search and getting an opinion letter from an attorney if you are considering registering a trademark. That research is just very crucial when it comes down to it, because that's just going to save you headaches in the future.
And if you've done this research and there's anything that you have questions about, it stands out to you, you're confused, does something seem too similar, you can come to the Pro Bono Center and speak one-on-one with an attorney for free about how to proceed. So just know that, if you're going to undertake all this research and Googling on your own, there is help out there.
Right, the Pro Bono Center is great for this, and anything that I mentioned, I'm sure Christine will attest to. They have attorneys on hand to assist you with these things.
Okay. So in terms of IP, who owns it? We talked about that it is owned, that there's protection, but we have several questions about who owns it. So starting out, if an owner of the business, for example, with your law firm, you create IP, you made the presentation for today, who owns that IP? Is that you as the owner or your business?
Yeah, that's a good question. It's up to you, right? Like I will give the example of my clients, which are software companies. The company owns everything. And the way that you make sure that the company owns everything is through legal agreements. So when a founder comes on board, you are signing an intellectual property assignment agreement or a technology assignment agreement, or as it's called. When you have employees, you have them sign technology assignment agreements, intellectual property assignment agreements that assigns all the intellectual property to the company. It is best practice, in my opinion, to make sure that the company owns all the intellectual property. However, that is a very personal decision as to how you want to approach that. I have seen instances where owners and founders insist on keeping the intellectual property to themselves and then licensing it to the business, which is also totally fine. You can do that too. But that is just, it's a more complicated answer than I can just give a yes or no to, or I can give a straight answer to. It just really depends on what your use case is. But for software companies specifically, because that's who I work with, it is best practice for the company itself to own all the intellectual property.
Okay. And you mentioned a word that some of our listeners may be familiar with and some may not. Licensing. Can you explain what licensing of intellectual property is?
Yeah, absolutely. So licensing is essentially like giving somebody the right to use something. That's really what licensing is. And you give licensing through licensing agreements. So for example's sake, like, think of it as the NBA. The NBA licenses out their name to all the products, all the hats that you buy, all the shirts that you buy with team logos. That's a licensing right there. And there's an agreement in place and there's payment in place, meaning like the NBA is getting paid $5,000. I'm just throwing numbers out there, $5,000 a year for Spalding to be able to use their logo on their balls and something like that. So intellectual property licensing, and it's not just trademarks, not just names. Intellectual property licensing is basically you get a legal agreement in place. In that legal agreement, you say, hey, I am giving you a limited right to use my name. In exchange for using my name or my product or whatever it is, my code, whatever it is, you are paying me $10,000 a year or whatever the amount is. So that's how intellectual property licensing works.
Jumping back a minute to who owns IP. Yep. Lots of businesses hire third parties, other businesses, independent contractors to create IP for their business. A graphic designer, a web designer, a photographer, a videographer, maybe even a coder. Who owns the IP developed by those third parties?
Yeah, that depends on your contract. And this is something that I negotiate with my clients a lot. They'll get agreements from a coder, from a developer, and we want to make sure that that agreement very specifically says that everything that's being developed is work made for hire. That's the term you remember, work made for hire, and that's signed over to whoever's buying it. So the answer here is if you don't have an agreement in place, a contract in place that spells it out, then probably the person who created it. But if you do have a contract in place, make sure that contract very specifically says that this intellectual property, this code that I'm developing for you, these photographs that I'm taking, these, whatever it is that I'm doing for you as a service provider belongs to you and does not belong to me.
Okay, so it looks like we're going to jump back a little to some of the topics we talked about earlier. For copyright, you had talked about the fact, and I'd asked the question, that just saying, on your copyrighted protected work, just saying it's copyrighted is sufficient for protection. Is that correct?
Saying it's copyrighted is sufficient for, so this is a tricky question, because if you want to go to court and protect it, you should register something, right? You should register it with the Copyright Office. Just saying that it's copyrighted just at least puts it out in notice that it belongs to you. Whether it would hold up in court is really dependent on the court. And that's really the only answer that I can give with that. It's very dependent on what it is that you're trying to protect, how amicable the court system is to a situation where you are just saying it's copyrighted, but it's not a registered copyright. Like it all depends on that.
Okay. In copyright, if a small business wants to use some music from, maybe a movie or a musician and alter it, they want to change it a little bit, but they're taking something that's copyrighted. Is that okay? Is that infringement?
No, get permission. Yeah, that's infringement. Get permission. Talk to Pro Bono Center. I don't know if you have connections to entertainment lawyers, but they'll lecture you on this. If it belongs to somebody else, it belongs to somebody else, and it's in your best interest to get permission of that. If you're doing a parody of it, even I'm not familiar. I'm not an entertainment attorney, so I don't know the specifics around it, but I do know that it is in your best interest to get a license, and this is where licensing comes back, to use that music for those purposes.
And for other types of intellectual property, maybe, I guess it could also apply to copyright, but this question is talking more about trademarks. Can you take something that is protected and change it? So for example, Nike, for the shoes, you take their logo and their little swoosh, and you change the color from what they have protected and add some flowers and designs around it, and use it for non-shoes, maybe for a computer. Is that okay if you modify it?
No, you shouldn't do that either. That's intellectual property of Nike, and Nike is notoriously, very strict about their intellectual property rights. They actually recently sued a rapper, Lil Nas X, because he's partnered with a different brand in order to recreate Nike Air Force Ones. And even though they're Nike Air Force Ones products, they're still using the Nike logo. Whatever you change, what you want to do, no matter what, the way to approach intellectual property, don't use someone else's, use your own. Come up with something of your own, because when you're piggybacking on the fame of another brand, such as Nike, such as Subaru, Spalding, whatever it is, that's where problems will arise. So create something original, and that'll be better for you, because honestly, just piggybacking off of somebody else's fame is just kind of taking the easy way out, which will end up getting you sued one way or another. So it's just best practice not to.
When a business has something that they think, this is copyrightable, I want to make sure that I'm taking the steps to protect this. In order for there to be copyright protection, does the work need to be published? For example, for a script for a movie or a play, people have copies of it, or the play be live, or for a blog post, the blog post's gone live and it's no longer a draft.
I'm not sure I understand the question. Does it need to be published? I mean,
yeah. So does it? Yeah. For copyright protection, does something need to be published and out there, or can it still be private?
Yeah, not necessarily. Like, it could be private if you want to. Like, once again, copyright protection technically comes into play as soon as you create something. But if you want it to be federally protectable, that's when you register with the Copyright Office. As far as, does it need to be published and out there in the open versus something that's in your room? I don't think you necessarily need to publish it out there in the open, but you can claim the copyright accordingly.
Okay. Keeping things hidden and secret, jumping back to trade secrets.
Sure.
Are there any specific steps that some businesses should take to keep a trade secret secret? You mentioned, obviously, don't have it easily accessible in a shared drive for people that don't need access to it. But are there, kind of general steps or tips or recommendations you have that apply to different types of businesses?
Yeah, yeah, sure. So confidentiality agreements is a big thing. Make sure anybody that has access to it has confidentiality agreements in place. Make sure you mark something as confidential. It's important to say that it's confidential, and then also act like it's confidential, right? Like, just don't leave it open somewhere. If it's going to be in a Google Drive folder, make sure it's a protected Google Drive folder and only shared with specific people. Those are the type of steps. But ultimately, there's kind of just a test that a court system will conduct as to whether something should remain a trade secret. And that test really, it's really dependent on how stringent you are about protecting that trade secret. So just don't make it generally available, and make sure you have appropriate agreements in place, confidentiality agreements, NDAs, whatever you want to call it, with whoever has access to it.
And you've mentioned employees with trade secrets. Can you keep a trade secret if it's shared with people outside of your business for business purposes? For example, a producer, a manufacturer.
Yep. Yeah, of
Okay.
course. But once again, it all comes down to the same agreements. Like make sure you have the appropriate agreements in place that say that, hey, this is a trade secret, this is confidential. Anything that's marked as confidential should be considered a trade secret, and so do not divulge that information to anybody else. So yes, absolutely, you can share it outside of your organization, but just make sure that you have the appropriate contracts in place with whoever's getting it.
Okay. So non-disclosure agreements protect a lot here. If you have a non-disclosure agreement, regarding maybe a trade secret, and it's for 3 years, and those 3 years are up, can your trade secret get out? And if
That's a good
so,
question.
how do you handle?
No, that's a good question. So most non-disclosure agreements, or a good non-disclosure agreement, should have a carve-out for trade secrets. It's not assumed, but it should have a carve-out. So when I draft an NDA, I have a specific line that says that the expiration of 3 years does not apply to trade secrets, and trade secrets should be kept in place until they are no longer considered a trade secret. Like that's something that I would add to an NDA, and that kind of adds that trade secret protection.
Okay. Because trade secrets, nobody knows them except the people you tell while keeping it secret. What happens if on their own, organically, somebody else comes up with the exact same thing, whether it's code or a recipe or a formula? Does the person who used it first win, or what's that look like?
Yeah, that really depends on, well, I don't know. The answer is I don't know. It depends on if you guys go to court, right? So say you're being sued for it. It's like, hey, I came up with this. Well, now the burden of proof is on you to show that, hey, I came up with it first. So have the appropriate like dates attached to when you came up with it. When did you publish the code, or when did you come up with the song, or all of that stuff.
So we talked about, music is something big that can be protected by copyright law.
Yep.
Wouldn't copyright law also protect the titles to the songs or the album?
Yeah, I mean they could be copyrighted. They could also be trademarked too, because those are names, those are words, right? So yes, copyright can protect that. You could also trademark names to albums or names to songs or whatnot.
It looks like that is it for our questions. So again, I want to thank you, Shahed, and thank all of our listeners for joining us. As I mentioned before, we're going to send out a survey to everyone who logged in today. So please share your thoughts on this great webinar, share thoughts on any topics that you're interested in for future webinars. And you'll also get access to the recording of today's program. You can share it with your friends. And remember, if you would like to speak one-on-one with an attorney for free about IP or any other legal matters about your small business, you view the Pro Bono Center's upcoming events and our online resource library. You can visit us at lawhelp.org/DC/NPSB as a nonprofit and small business. We'll also include this link in the follow-up email. And I cannot say this enough times again. Thank you, Shahed, for taking the time out of your schedule to share with us today.
Yeah, absolutely. Thank you so much for having me. Thank you for everybody that joined. I really hope you found this helpful. This is just a high-level overview. Obviously, there's more caveats. And of course, work with the DC Bar Pro Bono Center for your legal needs as necessary. And I hope to do more of these, so please stay tuned.
Great. Thank you so much. Have a good afternoon, everybody.